Hi, the question we're here to answer today is, what do you do if you've been served with a lawsuit? It could be any type of a situation. Could be something as, as simple as a trip and fall. It could be something as serious as an abuse claim. And it doesn't matter what kind of a lawsuit you've been served with. There's certain steps that you're going to want to take, and we've got questions. So right at the initial stage, we want some legal guidance. So that's why we brought in Bob Brockman from BQB Law. Hey, Bob.
Good morning, Charlie. It's an absolutely beautiful day outside. I'm glad we're able to do this.
Well, I'm really appreciative of having you take the time to kind of help us. I mean, I know there's many times when I call you, it's usually at 4:59 on a Friday, and a ministry just got served with a lawsuit. And, of course, you've got the pastor that's like, uh-oh, I've got to talk about this on Sunday morning, and they prepare something, and you and I are both sitting there. Okay, guys, let's just tap the brakes just a little bit and let's do
Exactly.
this the right way. So, Bob, can you tell me what a ministry should be doing if they've been served?
Sure. A couple of things we need to keep in mind is if they have been served, that means that litigation has already begun, and service of the lawsuit in a way is your notice or your invitation that you need to respond to this. One of the things that we need to focus on is the date that they are served because the time to respond is limited. It's usually 30 days. So we want to make sure that we respond within that period of time. Otherwise, there's the possibility that a default judgment could be taken against the ministry, and we certainly don't want that to happen. So within that 30 days, we want to make sure that we respond to it correctly. One of the things that you want to do right away is not call the plaintiff's attorney or not call the plaintiff themselves. I have had situations where ministries have been served and their inclination is to call the attorney that served the lawsuit and say, hey, what the heck is this about? We don't want to do that. We want to keep in mind that everything that is said in the course of the litigation could ultimately have to come out in your deposition. So we want to keep the discussion of it to a minimum. So who should you call? Certainly, if you're a client of BQB Law, then definitely give us a call. Let us know about it. Or even if you're not a client, you're still welcome to call us. If you have an attorney, let them know. And we would take steps immediately to ask you whether or not you have potential insurance that might cover this. So if you're not associated with BQB, you don't have another law firm that you deal with, make sure you call Church West immediately, and make sure that Church West gets a copy of the lawsuit. And the reason is this, you might possibly have insurance that would cover the claims that are made in the lawsuit. And the reason we want to do this quickly and the reason we want ministries to put Church West on notice of the lawsuit is because the insurance policy, as you know, Charlie, is a contract. And the contract has a number of provisions in it. And generally speaking, provisions that we see across the board in insurance contracts include the following. Number one, if a claim is being made, you have an obligation to timely notify the insurance company that a claim is made. So we want to make sure that we fulfill that obligation. Also, an insurance policy usually provides two basic benefits to the insured. Number one, indemnity. So if the insured has caused some damage, that the insurance company will respond to that and potentially pay that damage. But also, the policy provides a defense against a lawsuit that is filed. But their obligations, the insurance company's obligations to do all these things don't start, they're not triggered, as we say in this arena, they're not triggered until the insurance company is on notice of the claim. So we want to make sure that your ministries either contact us or certainly contact Church West immediately and get this submitted to the insurance company. Couple of other things to keep in mind if there is insurance, and we operate from the standpoint that there may very well be, and we want to make sure that we take all the appropriate steps if there is an insurance contract usually gives the insurance company the right to control the defense and to investigate the claims and those types of things. So it's very, very important that we let the insurance company know about the claim so that they can begin that process as well. And I think I've said a number of times already this morning, we need to do this stuff right away. Over many, many years, as you well know, Charlie, sometimes you'll have a ministry that gets a notice of a default judgment or something like that. And we say, well, were you served with the complaint? And they say, well, the member of leadership who normally would deal with this kind of thing has been away on a sabbatical, or they went on a long vacation, or whatever it might be, and the lawsuit got thrown into a drawer. We don't want that to happen because these time frames are running. So we want to make sure that it doesn't get put into a drawer. We want to make sure that even if you have looked at it and you have determined that these allegations are outrageous and completely untrue and all that kind of thing, maybe all that is accurate, but still we need to follow the process and respond to the claim in a timely manner. So those are things that we need to do. And then, as I see it, Charlie, there are some things we don't want to do. There's an old saying that I remind people of: loose lips sink ships. People that talk too much can sometimes get into problems or create problems in litigation. And as I mentioned earlier, everything that is said as part of your looking into this, you're investigating it, or anything like that, could potentially become part of your deposition. And depositions are an uncomfortable process, a very uncomfortable process. You will usually be asked in your deposition if you talk to anybody about the lawsuit, and you will be required to list the names of every person that you've talked to, when you talked to them, why you talked to them, what you talked about, all that kind of thing. So we want to limit the necessity of having disclosed all that information by limiting all of the discussion to start with. So clearly you can talk to your attorneys about it. You should definitely talk to people at Church West about it. You should speak with the insurance company representative when they get a hold of you. It's your obligation to cooperate with them and make sure that you provide them with any answers to questions that they have, any information that would be helpful to them. But with regard to doing things internally, it is always best that the number of people that know about this, that are discussing it, be kept in check. And usually your church board needs to know about the lawsuit. If they have discussions about it, it's always my recommendation that they do that in executive session with legal counsel present in the executive session.
Bob, what does that mean? If they were to go to executive session with attorney present?
Yeah, if there is an attorney present, then the discussion that we have with our client, in this case, the board is the representative of the corporate ministry. So they are, in the eyes of the law, they are the corporation. So when an attorney works with a ministry, we are actually working with a nonprofit religious corporation, and that corporation is represented by the board members. So when we have discussions with our client, our discussions are protected by the attorney-client privilege. That is intended to make sure that the client can give us all of the information that we might need to help them without fear that they might have to disclose something that is perhaps uncomfortable or derogatory or negative later on. And we can also then be in the very best position to offer them the best advice that we can as to how to proceed forward. So with regard to your question, Charlie, going into executive session, usually when boards meet, the secretary of the board has the obligation of keeping minutes of the meeting, everything that is discussed and that type of thing. When we go into executive session, we are going sort of off the record. There are no minutes kept of that portion of the meeting, so that the attorney-client privilege is protected. The attorney can speak directly with the board members, answer all of their questions, discuss the good, the bad, and the ugly of the case, if there is an ugly part of it, without fear that records will be kept in the minutes, which would ultimately be disclosed to other people. So we have a process where we go into executive session, we talk about the matter with the board, and then once the board reaches some conclusions, they can come out of executive session. And if they need to take some action, the minutes just reflect the action that they have taken, and we can guide them in that area.
Okay. Hey, let me ask you, what should a ministry not do?
Generally speaking, I would think that they should not undertake some investigation of the matter on their own. They shouldn't pick up the phone and start calling the plaintiff, person making the complaint, and talking to them or talking to their attorney. Because for a couple of reasons, everything that they do isn't protected by the attorney-client privilege because there's no attorney involved in it. They could, and I've seen this happen in the past, not knowingly make admissions that could expose them to liability. Their discussions, as I mentioned, will come out in the deposition. It could come out in trial testimony later on. So the investigation that they do, unless it's directed specifically by counsel, could adversely impact the defense of the case. In addition to that, as we mentioned earlier, and you would be the best person to address this issue because you're the expert with regard to insurance, but if I'm not mistaken, the vast majority of insurance policies that I've seen have provisions in them that say that the insurance company has the right to investigate the claim and control the defense, those types of things. And so we don't want to step on the toes of the insurance company because they have that right to handle that themselves. We don't want to interfere with their job in conducting the investigation. Does that answer the question, I think?
Yeah, because the insurance company, they're the ones paying the bill. You paid your insurance premium, they paid that bill. You want the insurance company to pay the bill. They're going to investigate it, they're going to control it, and yeah.
We certainly want to cooperate with them,
Sure.
and we're obligated to do that under the policy generally, but we want to get the best possible outcome. So the way to get the best possible outcome is to provide the insurance company all of the information that they may need and answer any questions that they have so that they can properly evaluate the claim and get defense counsel involved if necessary.
Yeah. And what we're also going to want here at Church West, we're going to want an incident report if you've got a record of something that happened. If there was any recordings of some of the location where the alleged incident may have occurred, you want to protect that. We want to hold on to that right away because sometimes I don't know that everybody's aware, but sometimes the tapes will automatically erase and it's recorded over. And
Right.
So we want to hold on to that as long as we can, start preserving evidence and gathering evidence. But I don't want ministries to start kind of looking for more evidence, going in front of the pulpit, on Sunday morning and saying, hey, want to let everybody know this happened. Does anybody have any information about this? Or were there any other victims?
Yeah, we don't want to do that. And you bring up a really good point, Charlie. Usually when someone calls our office and says we've just been served with a lawsuit, in addition to asking them about insurance issues and what happened and those kinds of things, we have a detailed discussion with them as to what evidence may exist. And evidence could be documents, it could be security videos, it could be any number of different things. It could be a rug if somebody tripped over a rug or something like that. And we want to make sure that all of that is secured so that we don't lose any of it because we may need it later on.
Bob, I appreciate you taking the time today, and I appreciate you answering the phone calls late on Fridays, over the weekends, late at night, early in the morning, and being that emergency, resource that we have. And so we appreciate you and all the folks at BQB. So thank you very much.
We're always happy to help, Charlie.
All right, thanks.
Thank you.